everybody, welcome back to Law Hero. My name is Jen. I make videos about the law, and today we're talking about FE1 property law, and we're looking at succession law, and in particular I'm talking about a judgment that came from November 2022 that's really going to help all of you in your exam. And this judgment was written about, and the judgment made the front page of the Gazette where solicitor Richard Hammond went through it. So I think what we'll do is just go down through some of the points from the article and discuss it, and yeah, see how we go from there. So Miss Justice Butler made a judgment in recalling in November 2022. And the case concerned the doctrine of dependent relative revocation. So as you all know, we study revocation under our FE1 course. So the factual background was uncontested. The deceased, a single parent without children, attended his solicitor in 2012 to make a will. Enjoying the testamentary freedom of this jurisdiction, he did not benefit immediate family. And after making a minor request, he bequeathed the residue of his estate to 4 named beneficiaries, who would, under this will, receive a 1/4 interest each. In July 2015, the deceased again attended his solicitor and created a new will. The purpose of making this will was to include a 5th person. As would be expected, it began by expressly revoking the predecessors, with the deceased noting that he was hereby revoking all former wills and other testamentary dispositions heretofore made by me. And the High Court agreed with that. But then 4 months later, in November 2015, the deceased again attended his solicitor, motivated by desire to undo the 2015 changes, remove the 5th beneficiary, and restore the distribution of the residue of the estate to the 4 beneficiaries from the 2012 will. At this point, things start to go awry. So the deceased solicitor advised that revoking the 2015 will by destruction would on its own revive the 2012 will. This was the advice given by the solicitor to the client, and we all know the rules around destruction. The deceased proceeded to tear up the will in his solicitor's presence and departed with 2 copies of the 2012 will, thinking everything was all right. Following the death of the deceased, a grant of probate issued to his executors. The unfortunate solicitor had erred in the advice and had overlooked or conflated the distinct provisions of sections 85 and 87 of the Succession Act 1965, which I'm sure none of my law heroes when they become solicitors will do. So let's look at revocation, section 85. Subsection 1 provides a will is revoked by its subsequent marriage unless the will was in contemplation of that marriage, whether or not expressed so as being, together with apposite provisions relating to civil partnerships. While most practitioners will be familiar with this provision, it is worth refreshing that though marriage revokes a will, subsequent separation or divorce does not. Clients in family law proceedings should be reminded of this state of affairs. Subsection 2 provides for revocation by another will or codicil, or by declaring in writing the intent to revoke executed in like manner to a will, or by burning, tearing, or destruction of it by the testator with the intention of revoking it, or by burning, tearing, or destroying it by some other person in the testator's presence with the testator having the intention of revoking it. It would appear that the deceased here tore up his will with the intention of revoking it. The second leg of the exercise of revoking the 2015 will was the matter of intended revival of the 2012 will, but section 87 says that a previously revoked will may only be revived by the re-execution of that will or the execution of a codicil demonstrating an intention to revive the previous will. Remember here in this case, factually, he was destroying the 2015 will to revive the 2012 will. Therefore, the putative revival of the 2012 will would require an active step on the part of the deceased above and beyond tearing up the 2015 will. Here, he didn't do enough. Had the deceased taken home the 2015 will, revoked it by destruction, and failed to revive the 2012 will through non-compliance with section 87 of the Act, having lawfully revoked his then last will and having not revived any prior will or replaced the revoked will with a new will, he would have died intestate because he would have had no proper will. However, the deceased in this case revoked the 2015 will under the advice of his solicitor as the necessary action to revive the 2012 will, which is where the doctrine of dependent relative revocation arises. This is a really rare doctrine and serves to save a will from revocation where such revocation occurs, where the testator is operating under a mistaken understanding or where the revocation is contingent on some occurrence that ultimately does not happen. The application of the doctrine was straightforwardly summarised in Dancer v. Crabb as, if the testator's act can be interpreted, whatever else I may do, I intend to cancel this will. From this time forth, the will is revoked. But if the meaning is, as I have made a fresh will, my old will may now be destroyed, the old will is not revoked, if the new one be not, in fact, made. There was no dispute that the deceased's intent was to remove the fifth beneficiary. Added to his 2015 will. Nonetheless, as set out by the court in Goods of Hogan and as cited in Butler's judgment, it is not the function of the court to give effect to the intentions of the deceased, even if ascertainable, but instead to determine whether the steps made by the deceased accord with the Succession Act. Ultimately, while the purpose was to remove the fifth beneficiary, the revocation of the 2015 will was contingent on the revival of the 2012 will. Section 87 steps was not taken to revive the 2012 will. Therefore, the 2012 will was not validly received. The 2015 will, who was revocated, was held to be contingent on such revival, was not in fact revoked. The court ordered that the grant of probate in respect of the 2012 will be revoked, cancelled and recalled, pursuant to section 26(2) of the Succession Act, which we don't really do in the FE1, but the original 2015 will had been torn up and was not available, and therefore they couldn't admit it as proof. Consequently, the court ordered the 2012 will be admitted as proof in terms of a photocopy laid before the court. As a result of the missed revival step to comply with section 87, the deceased ultimately gave 1/5 of the residue of the estate to a beneficiary whom he intended to exclude. The will he thought he had revoked and destroyed actually survived to be the document upon which the estate was distributed. Without the doctrine of dependent relative revocation, matters would have been no better, because in the continuing absence of an active formal revival of the 2012 will and in compliance with section 87, he would have died intestate, and therefore, with beneficiaries other than the 4 beneficiaries common to both wills, which was clearly not his intention. He wanted these 4 people to get his estate. Richard Hammond noticed here that section 87 was enacted at a time before hard drives or cloud storage, and that part of the Succession Act actually traces itself back to the Wills Act 1837, where literacy levels were much lower and the task of creating a will in manuscript form was onerous on solicitors, hence the reference to re-execution thereof. Given the conveniences available to modern solicitors, it is likely that the prospect of re-executing a previously made and revoked will should never arise. It is always a new will that is created, even if its contents mirror that of a previous will, save for the date of execution, and having prior will available for structure and guidance should assist. Moreover, creating the will afresh allows the solicitor to ensure that new instructions are captured, out-of-date names and addresses are updated, newer statutory references or drafting improvements are incorporated, and the questions of current testamentary capacity is given proper consideration. Then a new will is executed, and most firms are equipped to make a scan of that will to be saved under the client's file. A certified copy of the will should also be placed on the client's file. These are the safeguards to assist the solicitor should the need to prove the will in terms of a copy ever arise. So the solicitor who wrote this article says that there are a number of advantages to reinforcing the revocation clause in the new will by physical destruction of the prior will. It reinforces for the client that a new will has been put in place, and indeed that a distinct professional service has been availed by the client. It viscerally emphasizes for the client that the old will is defunct and precludes any contact from the client suggesting that the old will be restored without the creation of a new will. And it reminds the solicitor that any wish to reinstate the now destroyed former will requires active steps, legal advice, and drafting. So yeah, very interesting case around the destruction and the possible argument of dependent relative revocation. But as Richard Hammond says, if you follow the rules and you adhere to the Succession Act, you won't have to worry about that doctrine coming into play. I hope you enjoyed that video, and I will see you in the next one.